Can a lawyer win a case without citing dozens of judgments? Can a single bare act become your strongest courtroom weapon? Do senior advocates rely more on the bare act than on bulky case law compilations? The answer is yes. In fact, many experienced lawyers begin every legal argument with the bare act because judgments may change, but the statute remains the foundation of the law until it is amended by Parliament. In today's video, I will reveal 5 practical techniques and 3 professional courtroom tips that will help you read, interpret, and use the bare act like a seasoned advocate. If you are a lawyer, law student, judicial aspirant, or preparing for competitive examinations, watch this video till the very end, because the final tip can completely transform the way you prepare every legal case. I'm happy to share that our channel has crossed 1 lakh subscribers and received the YouTube Silver Creator Award. Thank you for your continued trust and support. For more legal awareness videos, subscribe free of cost. If you'd like to support the channel, you can become a member for 59 rupees or 119 rupees by scanning the GPay QR code on the screen. Thank you once again for your support. Today, I am going to share a courtroom secret that every new lawyer should learn at the very beginning of their legal practice. We often see junior lawyers entering the courtroom carrying bulky files full of judgments for their arguments. But when you observe experienced and senior advocates, you will notice that the most important book in their hands is the bare act, the original statute itself. Why? Because judicial interpretations may change, and a larger bench of the Supreme Court may overrule the decision of a smaller bench. However, until Parliament amends the law, the bare act remains the law in force. Therefore, if you learn how to read, understand, and effectively use the bare act in court, your arguments will become far more powerful, precise, and persuasive. In today's video, I will share 5 practical techniques and 3 professional tips that will help you truly make the bare act your most effective courtroom weapon. First technique: breaking down the ingredients. Never read a statutory provision like a story. Instead, break it down into its essential elements, commonly known as the legal ingredients. For example, under the Bharatiya Nyaya Sanhita, 2023, the offense of theft is established only when all the essential ingredients are present, such as dishonest intention, movable property. The property must be in the possession of another person. It must be taken without that person's consent. The property must be moved or carried away. Now consider this: if the prosecution fails to prove that the accused actually moved the property, then even if all the other elements are present, the offense of theft cannot be established. While arguing before the court, identify and explain each ingredient separately. The judge will immediately recognize where the prosecution's case is weak. Second technique: literal interpretation. Every single word in a statute carries significance. Pay particular attention to 2 words: shall and may. Shall generally denotes a mandatory obligation. May generally denotes discretionary power. If a provision states, "the court shall," your argument would be that the legislature intended to make the requirement mandatory. However, remember that depending on the context, courts may sometimes interpret the word shall as directory rather than mandatory. Therefore, always keep in mind the object of the provision as well as its judicial interpretation. That is the hallmark of professional advocacy. Third technique: never ignore the proviso. Many lawyers carefully read the main provision but overlook the short sentence appearing below it, provided that. Always remember that many cases are won or lost because of the proviso. The main provision lays down the general rule, while the proviso creates an exception for specific circumstances. If your client's case falls within that exception, the proviso can become your strongest shield. Therefore, before appearing in court, separately mark both the main provision and its proviso. Fourth technique: the power of the Non-Obstante Clause. Now let us come to one of the most powerful legal tools. If a statutory provision begins with the words, "notwithstanding anything contained in," understand that it carries special legal effect. This means that where there is a conflict, the special provision may prevail over the general provision. However, remember that this overriding effect operates only to the extent of the actual inconsistency or conflict. Therefore, while arguing before the court, you must demonstrate that a real conflict exists between the two provisions. Only then will this argument achieve its full legal force. Fifth technique: harmonious construction. Never read a statutory provision in isolation. Always read it in the context of the entire enactment. First, examine the definition section. Then read the preamble, and thereafter understand the relevant provision. When you demonstrate to the court that your interpretation is consistent with the overall purpose of the legislation, your argument becomes far more credible. Courts generally prefer an interpretation that gives effect to the statute as a whole rather than rendering any part of it ineffective. 3 professional tips. Pro tip number 1. Do not merely make submissions before the court. Take the judge directly to the relevant page and section. Say, "My lord, kindly see page 42, section 18 of the Bare Act." When the court itself reads the statutory language, the impact of your argument increases manifold. Pro tip number 2. Never underestimate the difference between and or. If the statute uses the expression A and B, both conditions may be required to be satisfied. However, if it says A or B, the fulfillment of either one of the conditions may be sufficient. Many important cases have ultimately been decided on the interpretation of just this one word. Pro tip number 3. Always begin your legal research with the Bare Act. First, read the statutory provision. Then study the definitions. Next, examine the relevant rules or notifications. Only thereafter should you read the judgments. Judgments interpret the law, they do not replace the law itself. Developing this habit will benefit you throughout your legal career. Conclusion. So, friends, today we learned how to make the Bare Act your courtroom weapon by breaking down the legal ingredients, applying the principle of literal interpretation, making effective use of the Proviso, identifying the Non-Obstant Clause, applying the principle of harmonious construction. If you begin applying these 5 techniques in your daily case preparation, your courtroom arguments will become more structured, more confident, and far more persuasive. Thank you for watching this video. If you found this information useful, please like the video, subscribe free of cost, and share your views in the comments. For more legal insights, do not forget to press the bell icon. I shall meet you again soon in the next video. Jai Hind! Jai Bharat!